Good evening to everybody. Welcome to the today class. And I told you that today is the last class because tomorrow I am flying. And today that I made it very much clear that I am going to deal the death in relation to tort. What is the maxim? Generally, we will say in the death in relation to the tort. Anyone? If you know it, you tell me. If you don't know it, you say pass on.
Pass on, sir.
And this we read it because I told you this case law that I'm going to use again. Class-23-03-2022 versus East India Company Limited's Hotels, East India Hotels Limited. There is a German pilot case law. I told you that again I am going to use this case law because the German pilot died. So the court has decided, see, when a man is no more over there, a lot of amount is paid to him and gratuity paid to him and many other under acts also paid to him. And then the maxim could be utilized over here is actio personalis maritor cum persona. That is the maxim that we used it. Yes, read what is posted on the screen. Anyone?
Good evening. Death in relation to tort. Professor Dr. Mohammed Saheb Hussain.
Yes,
Death
that is
in
the
relation
thing.
to tort.
Okay, of course, my other thing also I made it over there. But without wasting the time, let us go to the what is the death in relation to tort. So now instead of bifurcating that, let me stop the video so that voice will be the more. Okay, death in relation to tort. The claim for the compensation is usually brought by the person who has sustained the injury against the person who is responsible for the injury. The topic can be studied under the two broad heads. Number one, how does the death of one of the parties affect the cause of action? The second, how far is causing death actionable in tort? So let us see that how it can be done. Let us presume it. A person who has taken the loan, and that loan the father has taken and he spent for the purpose of the study to their children as well as their school fee. Now the person who has taken the loan died. The person who has given the money for the loan, if he comes and asks him, can the children of the deceased will say, my father has taken the money, my father is no more, then we are not responsible. If you want to get from my father, go to the hell or heaven, and he will meet over there and get the money from there. Can the children will say so?
No, sir.
Why? Why? If you
Pass
don't
on,
know,
sir.
just say pass on without wasting the time. So pass on.
Yes, sir. Pass on.
When the father property is there, for the property they inherit in the form of succession, then the father left some debts. Can't they clear the debts of their father? Yes,
Yes, sir.
they are supposed to do. They are supposed to do. They cannot say that my father is died. Because when you come across in the Indian Succession Act, there you will also read inheritance. First and foremost, some deductions are there. The deductions after meditor, then the remaining property is only heritable property. Of course, that is we are not going to discuss over here. So now the question comes over here. The father made the murder. When the case is going on, the father died. Can the son will be held liable for the father's murder?
No, sir.
Answer, no.
No.
The reason is the murdering is a personal act. So a person did it with his own skill. Either skill you say or his art, or by any other means, you say. When a person died, and his personal action also died. That is the maxim. So in some cases, maxim is applicable. In some cases, maxim is not applicable. Especially in the defamation case, in the assault case, in the battery case, if the person is no more over there, who is going to get the compensation? The person who filed the case is kicked the bucket. Means no more in this world, died. So actio personalis maritur or maritur cum persona. That maxim can be used. The personal action dies with the person. Suppose a person has made a contract and is a good painter, and he took the money and he should come to his house, the other person who loaned the amount, in his house they have to make the painting on the wall. After some time, that fellow is died. Let's say pandemic, he died. Can you insist his children to paint the wall?
No, sir.
Even though the son or the daughter or the mother or the sister or the anyone, including the wife, more beautiful painter than, more famous painter than the deceased, even that also you cannot insist them to paint, because painting is the personal skill. When the personal skill died with the person, you cannot force the another person to paint for him, even though he has taken the money. Are you following me?
Yes, sir.
So in some cases we'll say the maxim is applicable, but in some cases we'll say the maximum is not applicable. Is it clear?
Yes, sir.
Let us see in detail. So effect of the death on the subsisting cause of action. If the suppose somebody's died over there, whether the cause of action survives or not, according to English common law, no cause of action arises against the person who is dead. That is the common law principle. A man is died, everything is died. No question of answering. This rule is contained in the maxim actio or actio personalis moritur cum persona. The cause of action dies with the person. The cause of action dies with the person. And thus, if any of the parties dies, the cause of action comes to an end. I said any one of the party. The application of the maxim in India can be seen in the case of, let us see. Read the case law.
Babir Singh Makul versus Chairman, Sir Gangaram Hospital. A complaint was filed by Balbir Singh Makul against the surgeon alleging that his son died because of the blunder committed by the surgeon. While the proceedings were going on, the surgeon died. The National Commission of India applied the maxim actio personalis moritur cum persona and held that with the death of the surgeon, the cause of action has also come to an end, and therefore the legal heirs of the surgeon cannot be made liable for the same.
It is a very clear, self-explanatory. I don't know whether you followed or not. See, surgeon has done the blunder. Yes, I understand. And consequently, the patient died. And the person who filed the case is Balbir Singh Makol against the surgeon. And of course, he is running the chairman of the Sir Gangaram Hospital. While the proceedings were going on, the surgeon is died. So the National Commission of India applied the maxim actio personalis moritur persona and held that with the death of the surgeon, the cause of action also come to an end, and therefore the legal heirs of the surgeon cannot be made liable for the same. Sir, then how could the person who died because of the mistake of the surgeon will not be given any compensation, sir, here? So sometimes if it is very much proved that if the medical negligence done by the surgeon are there, at that instance, Even the decision given by the National Commission of India is also a wrong decision. Reason is, when the victim will not be compensated here. But I believe that some of the compensation might be paid, and some settlement was done, but still it is going on over there. But meanwhile, he died. The National Commission say, when the person is no more over there, you cannot make the legal heirs for the responsibility. But when the legal heirs got the money from the surgeon, means the earning, they can enjoy it. But here, I believe, whether you like this opinion of the National Commission or not. Tell me.
I don't like it, sir.
Pardon?
I didn't like the opinion of National Commission of India, sir.
Yeah, National Commission, they should have to make it out. See, the blunder you said committed by the surgeon. When the blunder is committed by the surgeon, even the surgeon died, but the estate is left. From the estate, the compensation should be paid to the victim. But anyway, that they use this maxim. So, exception to the maxim, let us see that. Action under the contract, no question. If the contract, personal action dies with the person, no. Legal heirs should be held responsible. The maxim does not apply to the cases where an action is brought under the law of contract. Therefore, the legal representatives of the person can be made liable for the performance. But if it is a personal skill, like the painter is there, yes, we cannot force the other people. Am I right?
Yes, sir.
Okay. However, if the contract entered into this contract, personal service, with the personal service skill, then the legal representative would not be liable for the performance. Thus, for example, there is a contract with A for singing on the particular event, and meanwhile, A dies. He made a contract with the theater, A, for singing there, but meanwhile, A died. Then the representative of the A cannot be made liable for the performance, because singing is a
Personal act.
personal act. Hence, we cannot enforce to their legal heirs. Now, again, this maxim cannot be used in the unjust enrichment of the tort of estate. If you unjustly enriched yourself, at that instance, you cannot say that the person who has taken the money, he died. If someone before his death has wrongfully appropriated the property of another person, then the person whose property has been appropriated does not lose his right to bring an action against the representative of the deceased and recover the property. Yes, because, for instance, you have taken that somebody has taken 4 quintals of the paddy as a loan. In the next crop that he is going to return it. After some time he died. Can you say my father is died, so no question of a contract will be exist? Your father died, but he has taken the 4 quintals of the paddy. The paddy is with you, you enjoyed it. Then they say, no, the personal representative, legal representative should have to pay, return back the amount or its equivalent amount. The rationale behind is that only the thing actually belong to the deceased can be passed to his representatives. So, what is passed to his representatives? If the property is there and just enrichment, then that will be given back to the person. It falls on their legal representative. There is a basic case law. Actually, this case law, we have to tell it before I could make it out. This is the case law. From this actual personalis maritum persona has come out in the picture. Read the case law.
Ambly versus Trott is one of the founding cases for the principle of the maxim actio personalis moritur cum persona. In this case, the defendant died after appropriating some farm animals from the plaintiff. The plaintiff then looked for a way to retrieve those animals from the estate of the deceased, but the plaintiff was not able to do as he wished, but at the same time, the court drew some rules by which any claim against an estate shall be successful. This was because of the fact that trespass would fail as it was against the person and not a property. Therefore, any action for a contract would be successful.
See, actually, this is the base of the case. Hamley versus Trott is the base where this person, he went into somebody's house I don't know whether he is borrowed or lent or taken, whatever the condition are there. They taken some of the animals from there, camels, horses, buffaloes, she buffalo, he buffalo, cow, and all those things. The defendant died after appropriating some of the animals from the plaintiff. So defendant has taken the animals from the plaintiff forcefully or in the loan or in any other form. Doesn't matter. Are you agreeing?
Yes, sir.
So naturally he has taken from the plaintiff. It is very much clear. The plaintiff then looked for a way to retrieve how we can get back those animals from the estate of the deceased. But the plaintiff was not able to do so as he wished, but at the same time, the fellow who has taken is died. There are two actions are there the plaintiff could have against the defendant. Number one, the defendant made a trespass to land in his property to take the animals from him. Number two, he's misappropriated the property and the property is with him. Are you following me?
Yes, sir.
So the court decided it. Trespass means that person who trespassed your property is no more because he died. So no action can be taken, not with the legal representatives. Are you following me?
Yes, sir.
Then the property which he has taken and forcefully from the plaintiff, that should be returned back. So there is no question of property. There we cannot say that. In the case of the property, you cannot say actio personalis maritime cum persona. That is, I told you, that is there. No one can enrich himself at the cost of others. So, regarding the property, he should have to return back. Regarding the trespass to land is concerned, okay, the person who trespassed the land is no more. Means we can use such a maxim. What is that? Actio personalis mariticum persona. The person who made a trespass is no more. The person who made a trespass to goods, the goods are with the representatives in the state. Yes, at the time, yes, one suppose if the goods he is sold away, let me presume it. Even though he is sold away, doesn't matter because he enriched himself and he should have to pay from his estate. Is it clear?
Yes, sir.
Yes, sir.
Actually, that is the base for this maxim. So now let us see that actually, you see what we are following only the English case law. So rule in the Baker versus Bolton English case law, it is very wonderful case law. It is also a leading case law, Baker versus Bolton rule. Therefore known as the rule in Baker versus Bolton, like the strict liability case law, the rule of
Ryland versus Fletcher.
Ryland versus Fletcher. So the absolute case law, the rule of absolute liability. What is the name of the case law?
Pass on, sir.
MC Mehta versus Union of India, that is the oleum gas case, Sriram Textile Mills. From there it has come out, but it is highlighted more in the MIC case law, methyl isocyanide case law. What is the name of the case law?
MC Mehta versus Union of India.
Union Carbide versus Union of India, that is
Union
the
of
case law.
India.
Yes. So in the Baker, Bolton, actually what happened, the plaintiff was held entitled for the injury to himself and also the loss of wife's society and distress from the date of the accident till her death, but not for the any loss caused after the death. See, this Bolton versus Baker versus Bolton case law is made clear. Actually, there's a horse-drawn cart. They are sitting on the top of the cart. And the cart become topsy-turvy, and they felt it. And the wife got the injuries. They say the word they used. The wife got the bruised. The word they used is bruised. BRUISED. Bruised at a kabali board on under. Are you getting me?
Yes, sir.
Bruised. 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 After some time, the wife died. So what the law says now, till her death, medical expenses can be claimed from her because the negligence on the part of the cart owner. Okay, whatever the thing which is there, including the consortium, mean the loss of the wife also he can get it. But once after the death of it, we are not supposed to get it. If the death has appeared over there, after death, no more compensation. Till the death, yes, whatever the amount you spend, he can get it. But the people said, See, after the death of suppose the breadwinner he died. The breadwinner is died on the spot. There is nothing in expenses are incurred because he died in the spot, on the spot. What about the dependents? Can they say actual personalis maritime cum persona?
No,
That
sir.
fellow has
Maintenance
made accident and that fellow died. Even some other people got injured and some other people also got died also. So they said, no, in this case, in the Motor Vehicle Act case, it cannot be done like that. From the state, he has to pay. The legal representative should have to get the company, pay the compensation. So then they say Baker versus Bolton case law is obsolete. It cannot be used at all now. Only in the rare cases it can be used. Let us see the another case law, Jackson versus Watson. In this case law, plaintiff purchased a tin of salmon. This salmon అంటే the fish పేరు అండి ఇది. మన దగ్గర అంటారు చూడు బొచ్చ ఏది మన ఏమంటారండి
Ravulu,
ఉన్నాయి
Bommadu.
కదా రాహు. So here also the salmon is there. They will it will be sold in the tin. Salmon, mackerels, tilapia, and perch, nail perch. These are all the type of the fishes. Some is water, sweet water fish. Some of them is sea fish. So salmon is very tasty fish. Mackerels are very tasty. Tilapia also very tasty. Nile perch also very tasty. So they purchased the salmon in the tin, defendant, from the defendant. The wife of the plaintiff died after eating this salmon fish. The consumption of salmon supplied by the defendant. It was found that the contents of the salmon were injurious to health. It became a toxic. The food poison అయిపోయింది. It was held by the court that there was a breach of a contract as the defendant has failed to supply the goods safe for consumption. Because it is nothing but a contract, the contract automatically, this maxim will not be
Applicable.
The plaintiff was held entitled to claim the compensation for the loss of services of the wife due to her death. Yes, even after the death also he can get it. Suppose the wife is a medical doctor. Now you tell me. And she has a government gazetted officer and she died on the 40 years. The probability that she will live at least for the 60 to 58 years. So multiplier theory will be applied over there. Whatever the compensation he has, she's going to get it in the multiple theory. Yes, that much amount should be paid by the person who caused such a death. Means manufacturer of this salmon. Are you following me?
Yes, sir.
So we do have so many cases like this, like the Girija Nandini Devi and others versus Vijendra Narayan Chowdhury. The court observed that stated that the personal action dies with the person, and when actual personalis mariticum persona was applied. If the skill is there, yes, skill we cannot force anybody. Is that health is legal maxim shall have a limited application. So this maxim is having limited application because in contract it cannot be worked. Of course, in the defamation it can be worked. The person who is defamed is no more over there, and who is going to get the compensation? Sir, the legal representatives. Actually, legal representatives are not defamed. The father is defamed. The father is no more. So only in assault cases, in defamation cases, in battery cases, yes, this maxim can be utilized. And the skill, a personal skill cases, yes, this maxim can be applied. So let us see the Sri Rameshwara Manjhi versus management of Sangramaghar collieries. What is that case law? Which was heard by the Supreme Court. It was held that this maxim has been under a lot of criticism under the common law as well as in England. So now the maxim we are not using at all, except in the few cases. This is due to the fact that it has been categorized as an unjust legal maxim, like the National Commission, it is given a wrong decision to my view also. Because the surgeon made the blunder at the time, naturally the person who got victimized, the National Commission, you are not supposed to say so. But anyway, that is, of course, if anybody is not happy by that decision, let them go to the Supreme Court. Are you following me?
Yes, sir.
So this is due to the fact that is then we categorize as unjust legal maxim because its expression is inaccurate or obscure in nature, which the end makes the application of uncertain. The court also said that the maxim has caused the grave injustice to the people. So now we are not using the maxim, but we are using only rare of the rare cases, especially the skillful cases. Of course, here also another, there is a case law, Vassala Srinivasan versus Shyamala Raghunathan. The court stated in the event where the executor of a will dies, the maxim will not be applicable to probate or proceeding shall be initiated by the executor. Suppose will, Tarvata, suppose he died, do you think that it will not be executed? There are executors are there. If the executor is not there, the court will appoint the administrator. Are you following me?
Yes, sir.
So in the money matters, in the property matter, the maxim will not applicable. Look, read this Noorani Jamal case law.
In the case of Noorani Jamal and others versus Naran Srinivas Rao and others, the applicability of this maximum in the context of motor vehicles accident was discussed in front of the Andhra Pradesh High Court. The single bench judge was confronted with questions like whether the claims for the damages survive even after the death or injury during a motor vehicle accident, and can the legal representatives take any action if there happens to be a loss to the property of the deceased. The court stated that the actions for damage claiming for personal injuries shall not die with the deceased person. The maxim shall not be used where there is a loss of property, virgule, estate of the deceased person.
See, in the motor vehicle accident, any one of the died doesn't matter. But still, the case will run because they're the loss to the property, loss to the life. Moreover, the dependents. What will happen to the dependents? So the maximum will not be applicable in the motor vehicle accident cases. In all cases, where the driver is there, so and so is there, something, it definitely goes to the legal representatives. So that is the, if you say that is the Prabhakara Adiga versus Gauri and others, the court stated that the normally personal action dies with the person, personal skills dies with the person, but this principle is application to the limited kind of cause of action. Yes, we told you already. The court also observed the actio personalis is moritur cum persona is in a principle used as a conjunctor and state that the personal action dies with the person has limited application. Now let us see the Girija, Nandini, Devi and others. Bijendra Narana Chaudhary. This is one of the case law. The cited in the case as well as that. Why the court also stated this principle operates in a limited class of action, which include the class of damages, assault and other types of the personal injuries, and that does not amount to other persons' actions where after the death of an individual, the granted relief cannot be enjoyed. So only the limited use would be there. In case of the assault, in case of the battery, in case of the defamation, in case of the skillful works are there only the maximum can be applied, but otherwise it cannot be applied. But I told you that the Class-23-03-2022 case law, I told you, Class-23-03-2022 case law, the maximum is used over there. Because they said, especially, see, they got the lot of, because there is a negligence on the part of the Oberoi Hotel, the Oberoi Hotels. So it will be represented by the East India Hotels Limited Corporation. But they said it is the negligence on the part of the hotel because they did not keep the depth of the water and the diving board. They are not proportionate to it. So occupier's liability would be there. And they also said it is run 14 years. He became a tetraplegic. 14 years the case has run. And in spite of that, of course, he got the gratuity, he got the compensation, and he got the many other things. But later on, again, the case is going on over there. Again, the court has used the maxim. What maxim the court has used? Here I am showing one of the, that's why I'm just, for the bereavement, of course, position in India, the Workman Compensation Act is there, the Indian Railway Act is there, the Carriage by Air Act is there, the Air Corporation Amendment Act is there, the Fatal Accident is there. So with that, the cause of action,
Dies with the person.
No, survives. Because if anybody got injury would be there, the cause of action will not die. The legal representative becomes they are becoming dependents and they are becoming a parasite and they will be thrown in the street. Hence, all these spaces, the maxim cannot be applied over there. But in one of the cases, La Buddha versus Union of India, it was held by the court that an action by the brother of the deceased is not maintainable as is not recognized as a legal representative under Section 1A of the Act. So naturally, brother will not be a legal representative in some cases. Who will be the legal representatives? Yes?
Children, father.
Yes, those are all people are comes as the legal representatives. But class meter bachat case law, I told you that the court has decision they have taken. The court, what the decision they have taken, this fellow has got the so much worth of money, but later on they filed the case. So class Betterwath case law, it says that the personal action will be died with the person only. So no more compensation will be paid because in the 14 years, whatever the compensation is paid is more than enough. So it is a single, it is a double bench, not single bench. It is a double bench has taken the decision and it gave the compensation. It is a closes the case. It closes the case in the class meter bachat case law. So that case law, you can refer it also, the actio personalis maritime persona, the case, this maxim is used over there, especially this maxim. So of course, there are many cases are there, which is where the maxim is applicable, where the see here, read this case law. I am searching for this case law.
Class Metal Bachard versus the East India Hotels Limited. On 13th August 1972, when a German national was residing at the Hotel Oberoi in New Delhi, the plaintiff in that case sustained severe personal injury in the swimming pool. The plaintiff filed a suit in the High Court of Delhi on August 11, 1975 for compensation of damages incurred by personal injury on 27 September 1985. 13 years after receiving the injury, the complainant died during the suit pendency. He has been tetraplegic due to the injuries sustained by the plaintiff. Cardiac arrest was the immediate explanation for death, and the tetraplegic disease was based on factual facts that the court acknowledged. Consequently, the court ruled that the death was due to personal injury in the swimming pool, and the case could not be abated, and the lawful representatives could continue the lawsuit. Alternatively, the suit was still held to be based on a contract with the hotel management and thus did not abate.
See, it is still based on the contract principle. That's why the case is not closed. Single bench has given the judgment. But it went to the division bench, double bench, and the division bench. In the division bench, what they said, no. See, the person who is almost all, they paid the lot of amount and still they are want to make it out. When the personal death is there over, then what would be the expenditure again? Because the dependent expenditure already they paid. Dependents. And whatever the thing would be there, because he died on the on roll call, means on the duty. So a child or the wife will be given a job also. So everything is died, but still they want to make it out. At that time, the division bench is used the maxim stating that yes, now no question of giving because the person is no more over there. Then whatever the amount will be paid to the dependents, and alternative they made the arrangement also for their survival. So when they made the alternate arrangement for the survival, they said, yes, this maximum would be applicable now. So they struck out the case law and say the maximum is applicable over there, they said in the division bench. See, there are two cases are there, class meter per chart. Because in one single bench, they say it is like a contract. So hence, the legal representative can entertain the case. But when it goes to the division bench, there they said, no, the person is no more over there. Whatever the amount they claimed it, they already claimed the benefit of it. All the benefit they claimed it. Again, after that, there is no question of any, because there should be some full stop. See, when a tetraplegic, you know, tetraplegic means the bones were, the backbone was crushed, especially 13th bone, then became a paralytic. He became a paralytic. Paralysis he developed. So he is like a vegetative state. He cannot move of himself. So he became a paralytic because of the the injury which is caused, because directly the skull hit the bottom of the swimming pool. But generally when you dive, you put the hand first. Are you following me?
Yes, sir.
When you dive, you put the hand first, so that the hand will touch it, the bottom. But I don't know how this fellow did it, because some people will dive keeping the hands behind. Are you following me?
Yes, sir.
Yes,
Yes,
I don't
sir.
know how this fellow did it, but in this case, they clearly mentioned no, they are not going to get any compensation for that regard. So that was the thing which is made in that case law. So overall, what I want to say is the actual personalis maritime cum persona. Do you think that still it is in continuation?
Yes, sir.
No,
Only in
Yes,
certain
yes,
situations.
Yes.
yes.
Yes, in certain
In
cases.
certain cases, still they are using it because they want to put the full stop. They want to put the full stop.
full stop
So
in the
still it can be used over there. See, common law, there is a good saying would be there in the common law. What is the common law says? No, even common law dies. Please note the point. Even though common law dies, it rule from the grave. Repeat.
Even though common law dies, it comes out from the grave.
Even though common law dies, it will rule from the
It will rule from the grave.
grave. That means it will not die. Are you following me? See, whenever the loopholes are there, either in the statute or in any other things, then the common law will come to the rescue. Common law will come to the rescue. So here the Fatal Accident Act 1855 will come to the rescue. What it says? Survival would be entitled to get the benefit even though the deceased is no more. Even all the Carriage by Air Act 1972 also said, in the carriage somebody's died. Do you think that the end of the chapter is closed? The dependents will
No,
get the compensation.
compensation.
The Indian Railway Act is there. If any accident happened to the railways, then their dependents will get the compensation. And those who are the legal heirs. If the Fatal Accident Act is there, yes, under it also, who are the dependents, the act itself clearly says. Suppose whether the married wife or a concubine will get it. Just tell me. అసలు ముందుగా చెప్పండి సార్, కన్క్యూబైన్ అంటే ఏంటి సార్? అది
Second wife or second son.
ఉంపుడు కత్తే. So the concubine is not said to be the married wife. Of course, in some places regarding the custom, they are the unions. Yes, she also entitled it because the custom will allow them to do so. At that instance, okay. But otherwise, a concubine will not be entitled to get it. But the union, they said, yes, union, they live together under the same roof for the 7 years and they do have the children. It's the presumption that they got married as per the Hindu succession, as per the Hindu Marriage Act 1955. So at the time, they don't say that they are not married together. Only the point is there is the stamping is not there, but they are living as a husband and wife and everybody knows it. So these are all the acts will say that the cause of action will be survives. The Merchant Shipping Act of 1979, yes, it also says the cause of action survives. Carriage by Rail Act 1972, yes, it also says that the cause of action survives.
Survives.
Yes, Carriage of Passenger by Road Act 1974, it also says yes. So compensation in the case of the death means definitely they are going to get it because the legal heirs, those who are become, they will be thrown in the street. So that was the reason. That is the reason that we can say that the maxim is no more applicable now, except the few cases when the rarest of the rare we can use it. Otherwise, we are not supposed to use it because if a person get enrichment, unlawful enrichment of the things. No, my father died and I don't know whether what he did with the money and he did not spend to us. He spent only for the drinking and playing the cards. Okay. But whatever the property your father left it, yes, from there you are supposed to pay it. When you are getting the benefit of your father property, why not the losses you should bear it? Are you getting my point?
Sir,
Yes,
if there is
sir.
no property, sir, what the children
Yes,
can do?
if there is no property, what do you do? Could you ask the son to sell the kidney? Yes?
No, sir.
Answer
Can't.
no. See, there is a law is there in the inheritance also. And first and foremost, the funeral expenses should be deducted. The next, whatever the medical expenses would be there, that will be deducted. Next, the person, those who render the services to him at the time of the death, that expenses should be deducted. Then whatever the wills, legacies he made it over there, that should be first cleared over there. Then if any other amount will be left over there, then it goes to the legal representatives. If nothing would be there, then nothing the legal representatives are going to get it. Is it clear?
Yes, sir.
Yes, sir.
One time that I told you. So we have successfully completed this death in relation to tort. That is the actual personality, maritime persona. But here, passing of conspiracy tort affected the family relations. Up to this extent, also we complete. What we have not completed is tort affecting family relationship, like wife, domestic violence, children's, the family disputes, a little that thing you have to make it out, and the damages, kinds of damages, judicial, extrajudicial remedies and judicial remedies, and these are the things we have to not dealt it. Of course, by going over there and the feasibility of the time and the internet connection over there, then I will intimate you in advance through my WhatsApp, which I am using now. The same WhatsApp would be used over there. Are you following me?
Yes, sir.
Okay, sir.
So that is the thing which I want to share it. So after going over there, let me concentrate on the damages, kinds of damages, judicial damages, extrajudicial. We can say remedies actually. We should not say damages, we should say remedies. See, this is the word.
Okay, sir.
See, this is the actual word. In the remedies, if an injunction comes, in the remedies, specific performance will come. In the remedies, type of damages comes. In the remedies, extrajudicial remedies also comes over there. You need not to go to the court of law. Like distress damage feasant. Suppose somebody's animal grazed in your land, you do have every right to tie that animal till you realize the amount from the owner of the animal whose animal made a loss to your property. Or we can keep in it's a pound. Yeah, it's a pound. We can keep in the pound, which is run by the Gram Panchayat. From there, they will you pay the amount, and some of the amount they will use it for the fodder, and some of the amount they will give to the owner of the land where the property is, where the animal is grazed. You know, grazed means grazing. GRA. What is the spelling?
GRAZING.
GRAZING. Then grazing antaru. అదే మళ్ళీ రేజింగ్ అంటే మరి వేరే RAISING. So now, on the next class that we will do it up to that extent that I would like to leave, and I want to say the goodbye. And thank you very much for your patient listening. And let
Thank
us
you,
meet
sir.
on the
Have a
Friday.
comfortable journey, sir.
Yeah,
We wish a
Friday or
comfortable journey
Saturday.
for you,
Yes.
sir.
Happy journey,
very
sir.
much. Thank you very much. Please, your blessing are with me, because the people will give the alms because they want to take the blessing from the others, because we don't know the God whose blessing will be fulfilled. We don't know. So please take the blessing of each and everybody, including your family members, because on whose blessing that power would be there, we don't know it. Hence, blessings are very much important rather than taking the curses. So with this one, I would like to stop my today's lecture. Then end of the lecture today, leave the meeting, end of the meeting. Yeah, it is the Indian tradition that in the beginning or the ending of this any program that we will make the play of the national anthem. Now the national anthem will be.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तां हमारा। जय हिंद।
जय हिंद।